closely right here. The federal social services agencies have created rules that allow the states to be responsible for the assessment, investigation, and intervention regarding any kind of child abuse or neglect, including sexual abuse. Every state has social services available, and Child Protective Services is just one branch of that. This is how it came to be. In 1967, a federal agency required every state to provide foster care services, but it was up to them to decide the details. In 1974, the federal agency said every state had to establish and publish their own abuse reporting and investigation procedures and systems, but again, up to the states how they want to do that. In 1980, the federal agency published the first set of federal guidelines for child welfare case management, permanency placing, and foster care placement reviews, and required every state to create, again, their own version of it, but an official, reasonable effort that would keep families together through prevention and reunification services. States also had to decide and define what the role of their state courts in child welfare cases would be, again, up to each state, how they did that. Then in 1997, President Clinton passed the ASF Act, which is basically what we use today. This federal legislation shifted the agency's objective away from reunification and prevention and placed a very heavy emphasis on child health and safety. It made the definitions of abuse and neglect more vague than ever before, which further enabled the state to define, interpret, and enforce the laws based on their interpretations. It validated the state's authority and autonomy over child welfare and social services, and interestingly enough, it allowed for the severance of parental rights if a child has been in foster care for 15 out of the last 22 months, with no consideration or caveat for court or social services delays. Sound familiar? Kind of like how the National Marine Fisheries Services was empowered to interpret and enforce a required inspector's costs be covered by fishing companies. While each state has a timeline for cases ranging anywhere from 30 to 90 days, many can drag on for more than 2 years, which far surpasses that 15 to 22 month guideline. And that's how states are able to terminate parental rights and are actually putting children up for adoption even before any abuse or neglect has been proven in court. That's a really big deal.